to order, and the first item on our agenda is the approval of the minutes from the May 10th, 2021 meeting of the Rules Committee of the Superior Court. Is there a motion to approve?
So moved, Judge Bellis.
Is there a second?
Second, Judge Trulia.
Any changes? All in favor say aye.
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 Opposed say no. That passes unanimously. I'm rude. I should have started by welcoming everybody back. I'm a little rusty on my organizational skills here. So welcome and thank you again for continuing to serve on this committee. So we have several items on the agenda that are all new. There are other items that are hanging out there in the background that are still being worked on and will make a reappearance at some future time on our agenda. But these are all new items that I may ask Joe to give brief descriptions of. The first item is 2021-008, a proposal from Attorney Zarella to amend section 23-1 of the practice book.
Yes, that was submitted by Attorney Zarella back in March. Actually, it came really too late for the last year, so it was put over, and this is the first time you really are considering it. Attorney Zarella has requested that section 23-1 be amended to include all of Connecticut General Statutes 909, which is all of arbitration proceedings. This rule currently only cites to three general statutes, which are, well, for some context, Chapter 909 is all about arbitration proceedings. It has Part 1 and Part 2. Part 1 is the Revised Uniform Arbitration Act. Part 2 is other arbitration provisions. And what Section 23-1 does is select certain of the other arbitration provisions and attaches to that the order to show cause procedures. The Part 1, I believe, the Revised Uniform Arbitration Act has in it procedures for seeking an application for judicial relief and certain service of process provisions. So I believe, and I could be corrected certainly, that Attorney Zarella would like the whole chapter placed into 23-1, which would make the, I believe it would make the show cause procedures applicable to all the different arbitration proceedings. So that's
Joe,
what you.
I can't see the, as I said, the list of participants. Is Attorney Zarella on the call?
No, he was not invited.
Do we have any guests on the call as well?
I'm sorry, I didn't get that.
Do we have any other guests attending the meeting? I can't see the list.
Yes, we have Judge Westbrook is in attendance, and I believe Mr. Chapman from the CBA.
Okay, thank you. So I have to confess, I have not thought about this in detail. I would assume that we would, I don't know if there's a specific section of the CBA that deals with arbitration, or maybe Attorney Chapman could let us know if there's a particular section that deals with arbitration in the CBA. Let's see if he's here.
I see that he was invited, but he apparently has not entered the meeting just yet.
Okay, we're getting off to a crackerjack start. All right, does anybody have any suggestions about stakeholders who might have an interest in weighing in on this subject?
Judge Bellis, besides the CBA, CTLA, Judge Abrams, that comes to mind. I don't know that it applies to family. I don't know.
I don't think so, but I wouldn't confidently say that.
Yeah, me neither. So if it did, then Judge Westbrook.
So why don't we refer to those entities for comment, Joe, and maybe you can take a closer look to see if there'd be any other organizations that would be appropriate to solicit input from.
Okay.
Is there any questions from any members related to that item? If not, we'll move on to the next is 2021-009, 011, a proposal from Judge Conway to amend section 27-1A and 27-4A regarding non-judicial handling of certain delinquency cases. And I see Judge Westbrook has joined us. It's good to see you.
Thank you.
And I can't remember everything, but are you the new CAJ for juvenile?
Yes, I am.
Congratulations and condolences all at once.
Thank you very much. And if you wish, if you wish, I can, speak to you about this proposal.
I would like that, please.
All right. So good afternoon, Mr. Chair, Justice McDonald, and to the other members of the Rules Committee. I'm Judge Dawn Westbrook, speaking to you as the incoming Chief Administrative Judge of Juvenile Matters. I'm adopting the previous submission submitted for your consideration by the former Chief Administrative Judge, Judge Bernadette Conway. Before you is a proposal to amend section 27-1A and 27-4A of the practice book to require that certain delinquency cases be considered for non-judicial handling, specifically to change the criteria to risk-based assessment rather than the charges that the youth faces. And included with the submission is information on why this amendment is being proposed. And, I'm happy to answer any questions to the extent that I can.
Are there any initial questions from members of the committee? If not, normally what we do, Judge Westbrook, is we kind of brainstorm about who the various stakeholders might be who would have an interest in this. We try to collaborate as best as possible with as many stakeholders as possible to hopefully address any issues on the front end of the adoption process rather than on the back end. So I guess I would turn it to you first and ask, who do you think would be the appropriate stakeholders who might want to weigh in on the subject?
Certainly, I'd say juvenile probation officers, possibly police departments, the public defender's office, the state's attorney's office, and of course, I guess the public. Those would be the main stakeholders in my opinion. And all of that, I'll just say, as you know, Juvenile Matters, there is the Juvenile Justice Policy and Oversight Committee, also known as JJPOC. All of those members are on that committee, and it's my understanding that this proposal sort of went through that committee and that they should all be aware of this proposal and that it was probably vetted through all of those entities before it was brought to your attention.
Okay, but given the fact that it has been several months since this proposal was sent to us, Joe, we should probably loop them back in as a stakeholder as well so that they know it's now percolated to the top of our to-do list.
Okay.
And Judge Westbrook, you said police. There's a Police Chiefs Association. Would that be the best conduit to engage the law enforcement community?
I would say that all of those entities would be captured in the JJPOC. There's a presence there. If you ran it by the JJPOC, each of those entities is represented at the Juvenile Justice Policy and Oversight Committee, which
and then it would filter down through.
Absolutely. Yeah.
Okay. All right.
Okay.
Any other recommendations from members of the committee? Forgive me, Judge Westbrook, given your understanding of this proposal in this area of the law, how long do you think we should afford these stakeholders an opportunity to provide, understanding oftentimes they have to wait for a next meeting so they can discuss it. How long should we give them to get back to us?
So the JJPOC does meet the third Thursday of every month. Our next meeting is September the 16th. In fairness, you couldn't make this month's meeting perhaps, but perhaps the following meeting, which would be in October. And after that, I would think that that would be enough time, because again, I already believe that they're aware of this proposal.
Okay. So, and that gives us enough time to, for the other end. By the way, is there I should know this perhaps, is there a juvenile section of the Bar Association?
There's the Office of the Chief Public Defender has what's called panel attorneys, which are private attorneys who represent parents and sometimes juveniles in child protection matters, but they also can be special public defenders in delinquency matters, which is what this proposal is pertaining to. So you can get an SPD for a delinquency matter.
There are private attorneys who do this work as well, though, right?
There are.
That's what.
Mhm.
Sorry, go ahead.
But again, so hopefully, I'm being clear. What this would do is mean that the matters would be non-judicially handled. So they would not come into court. So there wouldn't be any contact with private counsel or the public defender, because the juvenile probation officers would determine appropriate services for the youth, and they would not have to come in contact with the court at all. So,
No, I understand that. We have run into buzzsaws before with people, we assuming that people weren't interested, and they were. So I tried to be over-inclusive, but I appreciate that. At least, so let's plan on putting this back on for our November agenda.
Okay.
sounds good.
Okay.
Is that all that you have? Any other questions for me?
Any other questions for Judge Westbrook? Or she can go about her business. All right. Thank you so much for joining us.
Thank you. Thank you for listening to me. Thank you.
2021-13, recommendation from Legal Specialization Screening Committee for certification of the CBA to certify attorneys as specialists in the area of workers' compensation law for a period of 5 years. Joe?
Yes, that under the rule of professional responsibility 7.4B, the Legal Specialization Screening Committee vets these entities, reads all their materials, determines that they should or shouldn't be approved or reapproved, and they have done that, and they are making this recommendation to the Rules Committee, which actually adopt the recommendation and approve this entity. The CBA has been the entity to certify attorneys as specialists in workers' compensation for a number of years now, and it's been recommended that they receive another 5-year period of time within which they can be the certifier of attorneys in this area.
I don't think we could probably just act on this, can't we?
Yes, sir.
Okay.
You can.
All right. Are there any questions? If not, is there a motion to approve this item as submitted?
So moved, Avery Whetstone.
And it's been seconded by Judge Bellis. Any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. Next is 2021-14, a proposal from Judge Noble to revise the standard premises liability interrogatories. Joe?
Yes, Judge Noble submitted this back in June, or sent it in. It wasn't considered. This is the first time being considered. It was sent in June. He is requesting that certain of the plaintiff's interrogatories and requests for production be amended to include this information, a contract concerning snow and ice removal, and then materials concerning that contract be presented. So we have attached for you the 2 forms, and then his questions and requests have been provided by Judge Noble.
Did Judge Noble indicate the origin of why he was proposing this?
He said, I guess he was sitting on a trial and he noticed that this was not in these, he had a premises liabilities claim, and he noticed that these were not in the standard interrogatories, and he wanted to submit this request.
I guess I would first turn to Superior Court judges who have civil trial experience and ask them their thoughts about the proposal. No thoughts. Okay. I'm just trying to figure out whether this is something of sufficient frequency that should be incorporated in what Judge Bellis. I need more than the head. No, you're muted.
I'm sorry, I was just looking at the existing premises liability cases and I didn't know off the top of my head if anything came close, but I think it's something that occurs, you know, with enough frequency that it's something we should put out to the stakeholders.
Okay, certainly to the CBA and the CTLA and the Defense Lawyers Association. Anybody else, or does that pretty much cover the terrain, so to speak?
And Judge Abrams or CAJ Civil?
Yes, of course.
Yeah.
Okay, any other comments on that item? Again, Judge Bellis, do you have an idea how long we should give them to put it back on for our November agenda?
November seems reasonable to me. November or December. I mean, there's no urgency to it.
All right, let's put it on for November, understanding oftentimes it'll get kicked over to December anyway.
Okay.
Anything further on that? Okay, last item is 2021-15, a proposal from Chief Justice Robinson for a new rule eliminating peremptory challenges based on race or ethnicity as recommended by the jury selection task force. This is a big item, as both in terms of subject matter and in length, as the attachments indicate. And certainly we would want to also solicit the input of the task force itself, make sure that they know it's in the loop, that the task force that was co-chaired by former Chief Justice Rogers, and was it Judge Williams, Omar Williams?
I believe so. One second.
I don't know that he's moving on to greener pastures. I'm not certain what his status is, but in any event, let's make sure that the task force knows that this is on our agenda. The CBA, the CTLA, the defense lawyers. Anybody else? I mean, I bet you there are going to be several sections of the CBA who might want to participate or at least consider it.
Judge Abrams and Judge Gold, I guess we'll send it to, certainly.
Judge Abrams, Judge Gold, yeah.
Your Honor, just not to interrupt, but just so everything is clear, the Chief Justice's letter indicates that he was asking for this to be expedited under 1-9C, which I believe was intended to mean that a mail vote go out to the judges. But I just point that out. Not that I mean, it's with the committee certainly, but I just point that out.
No, I understand that, and I have the opportunity to chat with him in some frequency on the subject.
Okay.
We still have to make sure that the world knows what we're doing, so that they can participate in it as well.
Okay.
Okay. Any other stakeholders that anybody can think of on that item? If not, is there anything else that we need to address today, Joe?
There are actually, I don't know if everyone, hopefully everybody got this. There's a second page of the agenda.
Oh, no, sorry. I did not get it.
Okay, let me see if I can send it.
Take a recess in place, I think. Did anybody, Judge Bellis, did you get a second page? Okay.
Excuse me, it's Judge Avery Weston. I got a second page. I've got 2021-16, which is another recommendation from the Legal Specialization Screening Committee for bankruptcy.
Yes. Yes, there's two remaining. One is, as Judge Avery Whetstone says, it's a second application to the Legal Specialization Screening Committee from the American Board of Certification. They are currently certified to certify attorneys as specialists in bankruptcy, consumer bankruptcy law and business bankruptcy law. They have gone, their application has gone again to the Legal Specialization Screening Committee. That committee has recommended that they be approved for another 5-year period of time. And this identical except for subject matter and entity to the other one that you did a few minutes ago.
Okay, I see the supporting documentation. I didn't have the agenda item. Is there a motion to approve that certification?
So moved, Judge Bellis.
Thank you, Judge
Second,
Phillips.
Avery Whitstone.
Thank you. Is there any discussion? All in favor, say aye.
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 Opposed, say no. That passes unanimously. And Joe, could you walk me through the next one as well?
Yes, the last one is also by the Legal Specialization Screening Committee. They are required under the practice book rule, whenever they want to change their application, to present it to the Rules Committee. They have one small change in there. It's not a small change to them, I guess, but there's a small language change in their instructions on their application. And they want any changes, deletions, or additions to a prior application to be itemized in a separate document attached to their application so that they could readily understand what the changes in the entity's application are. So they have changed the form. The form was attached to the materials, and they need your approval to change that form.
That seems to make sense. Is there any discussion? Is there a motion to approve that item?
So moved, Avery Whitstone.
Thank you. Is there a second? Judge Bellis, I see, are you muted?
I'm muted. I was just making my way through the document. Sorry,
Got it. So you want us to pause for a second?
if you don't mind for me.
No, that's fine.
I'm sure it won't be a problem, but I'm.
Yeah, that's fine.
It's number 4 in the instructions, Your Honor. That's the new language.
I see it. I'm on board. So moved.
Okay, so that's the second from Judge Bellis. Any discussion? All in favor, say aye.
Aye.
Opposed, say no. The second page just showed up.
All right, sorry about that.
Is there anything further that we need to do today, Joe?
No, I just mentioned that you'll notice that Shauna O'Donnell's not on this call. She has moved on to another unit in judicial, but just let you know that because she did such great work for us. But we still have others here, and we will continue in our effort to assist you.
Okay, I appreciate that. Is there anything else from the members of the committee? If not, I will accept a motion to adjourn.
So moved, Judge Phelps.
Seconded by Judge Avery Whetstone.
Yes.
All right. All in favor, say aye.
Aye.
Say no. That passes unanimously, and we stand adjourned. Thank you, everybody.
Thank you.
Welcome back.
Bye-bye.
Yeah.
Bye.